Felthouse and Bindley was a case heard by the Royal Court of Common Pleas in England in 1862. While the case itself was a tort case suing in the tort of conversion, this case is an important precedent in contract law on the issue of offer and acceptance. A nephew, John Felthouse, who was selling all of his farming animals, had been negotiating with his uncle Paul Felthouse for the sale of a horse. The nephew had asked 30 guineas for the horse, and the uncle countered with a slightly lower offer of £30. There was some initial confusion over whether the sale had been made, so the uncle wrote again and said that he was willing to split the difference and pay £30 and 15 shillings for the horse. In his letter he said, "If I hear no more about him, I consider the horse mine at £30 15 shillings." The nephew did not write back, and the horse was sold at auction with the rest of the nephew's animals. The uncle sued the auctioneer, Bindley, for having sold a horse which he said was his. So the question for the court was really whether the uncle's offer had in fact been accepted by the fact that the nephew didn't write back to negotiate the price any further. If the offer had been accepted, then there was a contract for the sale of the horse. If the offer had not been accepted, then there was no contract, and the auctioneer was free to auction off the horse. The court found that the horse was not the uncle's horse because the uncle's letter saying that they should split the difference was no more than an offer. The offer could be accepted, or it could be rejected, or it could be withdrawn, but silence on the part of the person receiving the offer is no more than silence. It neither accepts nor rejects the offer, and you can't impose on the other party a condition that the offer will be considered to have been accepted if you don't hear back by a certain time. As Justice Keating said in the decision, a proposal had been made, but there had been no acceptance binding on the nephew. The legal principle flowing from this case is that an offer cannot be accepted by silence. In order to accept an offer, some words or conduct are required, and mere silence amounts to neither words nor conduct.